Debenture is an instrument evidencing debt. It may constitute a charge on the assets of the company. It is issued after approval by a special resolution from members. It will have option of convertibility on redemption wholly or partly. A debenture shall not carry any voting rights. Secured debentures are issued subject to terms and conditions. A company shall create a debenture redemption reserve to be used only for redemption of debentures, and it is created out of profits available for payment of dividend. The duration of a debenture is not to exceed 10 years, but in case of infrastructure companies, it can be up to 30 years. They are secured by a charge on the properties of the company or its subsidiary or holding or associate companies for due repayment of the debenture amount and the interest thereon. Company to appoint debenture trustee before the issue of the letter of offer and execute a debenture trust deed within 60 days of allotment, and the debenture trustee is required to protect the interests of debenture holders and redress their grievances. Section 44 of the Companies Act says shares or debentures or the other interest of any member in a company shall be movable property transferable in the manner provided by the articles of the company. A debenture trustee is required to be appointed before the issue of prospectus or letter of offer. His name appears in the letter of offer and in all subsequent communications. His written consent will be obtained before appointment, and it will be stated to that effect in the letter of offer. The trust deed in favor of debenture trustees will be executed within 3 months of the closure of the issue. The charge or mortgage created in favor of debenture trustee can be on any specific movable or immovable property. A trustee may be removed when consented by minimum of 3/4 in value of debentures. To ensure debenture trustee remains objective and impartial, he shall not be appointed as such if he is beneficially holding shares in the company, or he is a promoter, director or key managerial personnel of the company or its subsidiary or associates, or he is beneficially entitled to monies otherwise than as remuneration payable, or he is indebted to the company or its subsidiaries or associates, or he has furnished any guarantee in respect of the principal debts of the company, or he is a relative of any promoter or any person who is a director or key managerial person of the company. Debenture trust deed is a deed between the company and the trustees. Company mortgages to the trustees all the existing fixed plant and machinery and fixture as a security for due payment of principal with interest and other charges. Monies due to the debenture holders shall become immediately payable in the following eventualities: when the company makes a default, or the company ceases to carry on its business, or an order has been made by the court for winding up of the company, or it is certified by an auditor that the company's liabilities exceed its assets, or in the opinion of trustees, the security of debenture holders is in jeopardy. The trustee shall enter upon and take possession of the mortgaged premises as soon as the security is enforceable. He shall forthwith take steps for the purpose of determining whether the business may be allowed to be carried on, or the mortgaged premises shall be realized by sale or otherwise. A trust deed shall be open for inspection to any member or debenture holder of the company. A copy of the trust deed shall be forwarded to any member or debenture holder at his request within 7 days. A debenture redemption reserve is created out of profits of the company available for payment of dividend. It shall not be less than 15% of the debentures maturing during the year ending 31st March of the next year. The DRR shall be created in respect of non-convertible portion of the debenture issue. The amount credited to DRR shall not be utilized except for the purpose of redemption of debentures. The debenture redemption reserve will be maintained in deposits with any scheduled bank or in unencumbered securities of the central or state government. Tribunal helps Whenever the assets of the company are likely to become insufficient to discharge the principal, the debenture trustee may file a petition before the tribunal, which after a hearing may impose restrictions on incurring of any further liabilities by the company as felt necessary. Where a company fails to redeem or pay interest when due, the tribunal may on application and after hearing direct the company to redeem the debentures with interest forthwith. Sections 73 to 76 of the Companies Act, read with Companies Acceptance of Deposit Rules, contains conditions for acceptance of deposits by companies. Section 2, subsection 31 says deposit includes receipt of money by way of deposit, loan or in any other form by a company, but it doesn't include such categories which are prescribed under Rule 2, subsection 1, clause C of the Companies Acceptance of Deposit Rules 2014. Two types of depositors: member under section 73 subsection 2 and any person who has made a deposit as per section 76. Section 73 subsection 2 provides for accepting deposits from members subject to fulfillment of certain conditions, passing a resolution in general meeting, filing a copy of the circular along with the statement with the registrar within 30 days before the issue, depositing every 30th April 20% of the deposits maturing in the following financial year under the bank account, deposit repayment reserve account in a scheduled bank, the amount not to be used except for repayment of deposits, arranging for providing security for due repayment of amount of deposit and interest thereon. Where a company doesn't secure the deposits shall be termed as unsecured deposits. Section 76 talks of eligible company as a public company which has got a net worth of not less than rupees 100 crores or a turnover of not less than rupees 500 crore. Such an eligible company, before making any invitation to the public for acceptance of deposits, obtains the prior consent of the company in general meeting by means of a special resolution, and such a resolution is filed with the registrar before proceeding further. A public company having specified net worth or turnover under section 76 subsection 1 may accept deposits from persons other than its members, but it should obtain a credit rating from a recognized credit rating agency and inform the public about the rating given to the company at the time of invitation of deposits, and the rating should be obtained for every year during the tenure of deposits. The company accepting secured deposits from public has to create a charge on its assets within 30 days. A public limited company is permitted to accept or renew deposits for 6 months and above up to 36 months, and the company referred in 73 subsection 2 allowed to accept from members not to exceed 10% of its paid up share capital and free reserves and security premium account. Companies referred to in 76 subsection 1 to accept deposits from public not to exceed 25% of the aggregate of the paid up share capital, free reserves and securities premium account. A company accepting deposits shall dispatch a circular to its members or publish it as an advertisement, and such circular shall be signed by a majority of directors, filed with ROC at least 30 days before its issue, and such circular or advertisement remains valid for 6 months from closure of the financial year. The company will appoint a trustee for depositors for creating security for its deposit, and a deposit trust deed executed at least 7 days before issue of circular. Security will be created in favor of a trustee by the company inviting security deposits on movable or immovable property for due repayment of the amount of deposit and interest thereon. The company shall maintain a register of deposit entering particulars of each depositor within 7 days of issue. It shall file a return of deposits with the registrar on or before 30th day of June every year and furnish information as on 31st day of March duly audited. It shall furnish deposit receipts to the depositors for the amount received within a period of 21 days from the date of receipt of money or from the date of renewal. Company shall maintain liquid assets under deposit repayment reserve account on or before 30th April of each year with any scheduled bank, and it shall be utilized for repayment of deposits. Any contravention of section 73 or 76 will render the company liable for action under section 447. Section 2, subsection 16 of Companies Act defines charges as an interest or lien created on the property or assets of the company or on any of its undertakings or both as security, and it includes a mortgage. Two parties to a charge, borrower the creator of charge and lender the holder of charge. The agreement of charge is required to be in writing. The charge must be created against an immovable property, existing or future, but belonging to the borrower. There must be a clear intention to use the property as a security for the repayment of the borrowed money coupled with interest. A charge is wider than a mortgage. Two types of charges, fixed and floating. Fixed charge is created over specific and identified as fixed assets, and under a fixed charge to sell or dispose of the asset, previous approval of the lender is necessary. But in floating charge, which is not on a particular asset, the borrower has the right to sell in the ordinary course of business. But in insolvency, preference is given to a fixed charge over floating charge. A floating charge crystallizes into fixed charge under two circumstances. First, when the company is about to wind up or a receiver is appointed by the court, and second, the company has defaulted and the lender has taken recovery action. Registration of a charge. Every company creating a charge on its property or its undertaking, whether situated in or outside India, is required to register particulars of the charge with the registrar. It has to be done within 30 days of its creation, together with instruments, if any, creating such charge. Registrar is allowed to permit registration even in 60 days on payment of an additional fee as prescribed. Such delayed registration shall not prejudice right acquired by others before the charge is actually registered. On registration, the registrar shall issue a certificate of registration to the company and also to the person in whose favor the charge is created. The charge created by the company shall not be taken into account by the liquidator or any creditor unless it is duly registered and a certificate of registration is obtained from the registrar. When a company fails to register the charge within a period of 30 days, the person in whose favor the charge is created may himself apply to the registrar for registration of the charge. The registrar, after giving notice to the company, may within a period of 14 days allow such registration on payment of the prescribed fees. The person in whose favor the charge is created is entitled to recover from the company the amount of fees or additional fees paid by him to the registrar. Where any charge is registered, any person who acquires such property shall be deemed to have notice of the charge from the date of such registration. The registrar shall keep a register containing particulars of the charges registered in respect of every company. The register shall be open to inspection by any person on payment of prescribed fee for each inspection. In the normal course, on full payment or satisfaction, the company has to inform the registrar within 30 days. However, the registrar can allow such intimation even up to 300 days, provided an application with payment of prescribed additional fees is made by the company. Once intimation of satisfaction is received by the registrar, within the subsequent 14 days, he shall cause a notice to be sent to the charge holder, calling upon him to show cause why satisfaction in full should not be recorded. If no cause is shown, the registrar shall proceed recording the satisfaction of charge in the register of charges and inform the company. The registrar can act suo motu even when no intimation has been received by him, but on evidence being given to his satisfaction that the debt for which the charge was given has been paid in whole or in part. He may enter in the register a memorandum of satisfaction accordingly and inform the affected parties within 30 days of passing the entry. Every company shall keep a register of charges at its registered office in the prescribed form, and it shall cover both fixed and floating charges, and a copy of instrument creating the charge shall be kept along with the register. The register shall be open for inspection, free for members or creditors, and on payment of fees for others. When any person receives an order appointing him as a receiver or manager of a property which is subject to a charge, he is required within a period of 30 days to give notice of his appointment to the registrar and also to the company with a copy of the order, and he is also required to inform the registrar when he ceases to hold such appointment subsequently. On registration, the registrar issues certificate of registration in form number CHG2, and for modification of charge, the certificate will be issued in form CHG3. The certificate issued by the registrar shall be a conclusive evidence that the requirements of Chapter 6 have been complied with, and if a person willfully furnishes false or incorrect information, he shall be liable for action under Section 447 of the Act. In a special situation where the instrument creating, modifying or satisfying a charge is not filed by the company or the person holding the charge within 300 days, there is a special provision enabling the central government to permit such registration, provided the government is convinced of the sufficient cause and it is not prejudicial to creditors or shareholders. The government may direct that the time shall be extended and the omission be rectified. Under Section 88, a company is required to maintain register of members for each class of equity and preference shares in form number MGT1. In form number MGT2 will be maintained register of debenture holders. Company will also maintain register of any other security holders and foreign register of members and debenture holders. Register and index in respect of beneficial owners will be maintained by the depository under Depository Act 1996. Within 7 days of obtaining approval for allotment, transfer, transmission of shares, debentures and other securities, and for buyback, sweat equity issue, reduction of capital or subdivision or consolidation of shares, at the meeting of the board or at a meeting of its duly authorized committee, the company shall make entry in the register maintained at the registered office of the company. The registers with index, when authorized by a special resolution, can be kept at a place other than registered office, provided it is kept within the city in which registered office is situated. In case of a listed company, it shall also record pledge, charge, lien or hypothecation by promoters within a period of 15 days of such event. It shall also record any order from SEBI or competent authority attaching security, dividend or interest. It is required that the entries in the register and index shall be authenticated by the company secretary or any other person as authorized by the board of directors. The register of members, debenture holders and other security holders can be closed by the company for a period not exceeding 45 days in aggregate in every year, but it can be closed at one time for a maximum of 30 days, subject to a prior notice of 7 days or such lesser period as may be permitted by Securities Exchange Board of India in case of a listed company. The registers shall be open for inspection during business hours for not less than 2 hours on every working day at timings as decided by the board of directors. For members, debenture holders and other security holders and beneficial owners, it will be without any fee, and for any other person on payment of such fee as may be specified by the Articles of Association. Register of members are preserved permanently and kept under custody of the secretary or any other person as authorized by board. Register of debenture holders and other securities are preserved for 8 years from security redemption. The registers and their indices shall be prima facie evidence of any matter directed or authorized to be inserted therein by the Act. Declaration of beneficial interest. A person whose name is entered in the register of members as a holder, but who doesn't hold beneficial interest, is required to file declaration in MGT 4 within 30 days after his name is entered in the register. Similarly, the person acquiring beneficial interest is required to file within 30 days a declaration in MGT number 5 disclosing such interest of his. Declaration of beneficial interest. A company is required to make note of such declaration in the register of members and file MGT 6 with ROC within 30 days of receiving such declaration. Where the beneficial owner fails to make a declaration in MGT 5, no right in such share shall be enforceable either by him or anyone claiming through him. Annual return. Section 92 prescribes that every company shall file an annual return in MGT 7. It shall contain particulars as at the end of financial year comprising registered office and principal business, its holding, subsidiary and associate companies, shareholding pattern, pattern of debenture holders and pattern of other securities. Companies' indebtedness, members, debenture holders, changes since close of previous year, promoters, directors and key managerial personnel with changes in the financial year, meeting with attendance details in respect of meeting of members, directors, committees, etc., remuneration to directors and key managerial personnel, penalty and punishment imposed on company, directors and officers, details of compounding of offences, penalty or punishments appealed against, details in respect of shares held by foreign institutional investors, other matters as may be specified. The annual return shall be signed by a director and the company secretary. In case of a listed company or a company with paid up capital of rupees 10 crore or more or turnover of rupees 50 crore or more, annual return shall be certified by a company secretary in practice in MGT 8 to the effect that the company complies with all provisions of the Act. The company shall place a copy of annual return on its website, and its web link will be disclosed in the report of the Board of Directors. Every company shall file with the registrar a copy of annual return within 60 days from the date on which AGM is held, or AGM should have been held along with reasons for not holding AGM. A copy of the annual return shall be kept at the registered office of the company. It shall be preserved with all annexures for 8 years from the date of filing with the ROC. Copies of annual return shall be open for inspection during business hours for not less than 2 hours on every working day at timings as decided by the Board of Directors. No fee shall be charged for members, debenture holders, other security holders and beneficial owners. For any other person, it shall be on payment of such fee as may be specified by the Articles of Association. Company shall furnish copies of annual return to any member or any other person on payment of such fee as may be specified in the articles, and it shall be furnished within 7 days from the date of deposit of fee to the company.